important one, 150 you can ignore, 151 is an important one. Almost every alternate attempt you will see, or almost every attempt you will see this section in examination. 99.999% students will do mistake with respect to this section. And they will not read the question properly. Students have a problem in reading the question also. So in the question he will start stating that unlisted public company want to appoint small shareholder director. So this section is applicable only to listed companies. So listed public companies only it is applicable. This section is applicable only to listed public companies only. It is not applicable to other than listed companies. So if a question is being given under this section, first you have to find out whether it is a listed company or unlisted public company. If it is a listed public company only, this provision is applicable. Then you have to talk about how the question will be framed is every condition of this section will be there, and you will be reading the question, and you will have that saying that yes I know this question, yes I know this question, and you will have greatest confidence in writing the question. In the result you will see that when you get your answer paper back after the result, you will be coming to know array this was a mistake known, and you do normally. So this should not have done. So recent examination that I have conducted at our academy, so essay 240 question it was primary responsibility of prevention and detection of fraud error. Student knows very well it is a primary responsibility of management, but she has wrote primary responsibility of auditor. And when I questioned her, she is saying like, no sir, I wrote it as primary responsibility of management only. And when I have shown to her, no you did not write as management, you wrote it as auditor, then she realized. That means even you know when you are writing, you overwrite. So you write it as some other thing. So therefore when you are writing also you should be very, very careful. So coming back to this section 151, small shareholders directors. So when you are talking about applicability, so it is applicable only to a listed company, and there is a procedure for appointment, and you should also understand the name says small shareholders director. Who is said to be a small shareholder? Under the provisions of Companies Act, whose shareholding and shareholding face value, nominal value I am talking about, not the market value. In the question he will confuse you stating that nominal value is so and so, market value is so and so, registered value is so and so, X numbers he will give, and you have to consider only face value, that is nominal value, and how much it should be? 20,000 rupees. Then only, not exceeding this amount, he is said to be small shareholder. And the procedure for appointment is first sumoto company may appoint. That means without intervention of small shareholders, company itself may decide and appoint a small shareholder as small shareholder directors in the interest and benefit of the small shareholders, or on receipt of application, that is notice or application. So on receipt of notice or application, company may appoint small shareholder directors. So here who shall give notice, to whom they have to give, what is the time period, what contents that notice should have is important in examination point of view. On this only he will test. So notice shall be given by 1000 small shareholders or 1/10 of small shareholders. Of this whom sir, lower of this, whichever is lower, sometimes 10 members can also give, and that application is said to be valid. Why? Because 1/10 of small shareholders it is told. If company has more number of small shareholders, then 1000 shareholders concept will come into. If company has less number of shareholders, then 1/10 number of shareholders can also give. So that is small shareholders only, and this has to be written and signed by lower of them. And how many days before they have to give is 14 days before general meeting for appointment they have to give this notice. And what they have to include sir, they have to provide the details of small shareholders who are giving that candidature, and details of small shareholders director. So which shareholder will be director, and sometimes small shareholders may select a person who is not a small shareholder also as their director. Under provisions of section 151, there is no condition that small shareholder only should be the director. So even non-small shareholder can also become the small shareholders director. And a person who is being appointed will proposed to be appointed, his DIN should be provided, his consent should be given that he is willing to be appointed as SSD, and a statement that he is not disqualified under the provisions of Companies Act 2013. So always remember, disqualification provisions are under section 164 of Companies Act. So always we consider that 164 whenever provision disqualification comes. So if sumoto company may appoint or on receipt of application, how many members should give an application? 1000 members, and 1000 members of whom? Small shareholders only, or 1/10 of small shareholders should give this application, whichever is lower. And how many days before? 14 days before this has to be given, and they shall provide the details as following: details of that small shareholders and details of that small shareholder director also. And application should be accompanied by DIN, consent, and statement that he is not disqualified. And section 153 is also being amended. For your knowledge, 153 is DIN provisions. So now DIN is not compulsory for appointment of directors. So what is required, we will see under section 153. DIN is not compulsory now. So further provisions are there. So further provisions are regarding the same. Provisions regarding small shareholders director, he will not retire by rotation. He is not said to be rotational director. His appointment is valid maximum tenure of 3 years only. So small shareholder director can be appointed for a maximum period of 3 years. Sir, whether he is eligible for reappointment? No. Sir, can I consider small shareholder director as independent director under 149? If criteria specified under section 149 that he is not having pecuniary interest, not a shareholder, not a relative, if those conditions are satisfied, he can be called as independent director and counted for that 1/3 or 2 directors. But appointment is not under 149, appointment is under 151. Sir, if he is under 140, if 151 is been appointed, if he can be called as independent director, can he be reappointed for second term? No, appointment is not made under 149, appointment is made under 151. But he can be considered for the purpose of count made under section 149. Why? Because he is not having any nexus with company. Further, whether he is eligible for reappointment, I just told he is not eligible. And how many companies he can be appointed as small shareholder directors? Maximum 2 companies he can be appointed as small shareholder directors, provided both companies are not in competition. So the both companies should not be in competition. So if I am being appointed as a small shareholder director of one company which is in tire business, another tire business company can appoint me as a small shareholder directors? No. So cement company may appoint, but maximum appointment should be 2 only. Further, disqualifications provisions under made section 164 and vacation of office provisions made under section 169, 167 are equally applicable for small shareholders director also. And section 169 is also applicable. That is, removal of director is also possible for independent director also. It is possible that he may be removed, and small shareholder director may also be removed. So right. So now we'll be starting with section 152, appointment of directors. In this appointment of directors section 152, you'll be understanding appointment of first director, and you'll be also understanding what is the concept of rotation and appointment of rotational directors and reappointment of this rotational directors. So first, my question is, at the time of incorporation of the company, whether we'll provide appointment of director in articles? Yes, in articles we provide who are said to be first directors of the company, and there is a possibility in articles we may not include also. If a person is not being included as first director in articles of the company, who will be the first directors of the company? So in such case, every subscriber who is said to be an individual. Why? Because other than individual cannot be appointed as directors, and subscribers can be other than individuals also. Therefore, every person who is individual who are subscribed to memorandum, then they are said to be first directors of the company. Sir, there is a possibility that no individual may be subscribed to memorandum. All the subscribers to memorandum are other than individuals. Then in such case, who are said to be first directors of the company? So there will be no first directors, or there will be first directors. So in such case, appointment of directors will be made by shareholders only, and they are said to be first directors of the company. So again I am repeating, If provided in articles, they are said to be first directors. If not provided in articles, individuals who are subscribers to memorandum are said to be directors of the company. If all the subscribers are not individuals, then in such case, shareholders only will appoint the first directors of the company. This is appointment of first directors. And sir, for appointment, whether any information has to be given by directors to company and company has to file with ROC? Yes. So first director has to furnish his director identification number, and now section 153 is been amended, that is application for DIN. So now DIN can be, other than DIN also can be appointed as a director. So what is that other than DIN means? Any other number prescribed by CG, and as of now no such number is being prescribed, but shortly you will see Aadhaar number will be prescribed for appointment of directors also. Shortly you will see that. But one of some of the amendments that are made by the government, they are exceptionally good, like section 139 is being amended regarding appointment of auditors. So every year again ratification has to be done under old provisions, but by Companies Amendment Act 2017, if auditor is been appointed for a term of 5 years, no ratification is required. Why? Because it is contravening the provision of section 140 regarding removal of director. If removal has to be done, then CG approval was required with special resolution. But under 139 it is being told that ratification has to be done every year. If shareholders don't ratify, he is said to be removed. So therefore there is a conflict between 139 and 140. So therefore it is amended. Like this amendments are so many in Companies Act 2013 by Companies